Hello and welcome to Daily News Simplified, an answer to what, why, and how of newspaper reading. Let us discuss the important news appearing in the New Delhi edition of the Hindu newspaper dated 25th February 2020. The news to be discussed has been displayed on your screen and timestamping for the same has been provided in the description box below. So let's start our today's discussion. The first news appears as a lead article on page number 10. It says, the unassailable keywords for the judiciary. India's judges must remind themselves constantly of the need to uphold an independent, strong, and respected judiciary. Now, these three words with respect to judiciary, that is, independent, strong, and respected, becomes the most important aspect of this entire article, whereby the author, who is a senior advocate of the Supreme Court, has raised certain questions when a Supreme Court judge praised the Prime Minister of India on an international forum. So, with respect to this entire discussion, we have divided this topic into four main important aspects. As this topic of independence of judiciary is very important not only from prelims perspective but also from perspective of our mains examination. As question can be asked in GS paper 2 or even in GS paper 4 with respect to judicial ethics. So, in this regard, let us discuss about this article with respect to these following questions. First, is the praise of Prime Minister from a Supreme Court judge a bad idea? Second, why is an independent judiciary important for any democratic country and also for India? Third, what are the salient features of judicial independence as mentioned in the Indian Constitution? And fourth, what shall be the standard of conduct for judges of high courts as well as Supreme Court? And in this regard, this article has mentioned about a charter, namely the restatement of values of judicial life, which mentions 16 important points to be followed by judges of Supreme Court. So, in this regard, let us understand this article from the perspective of an independent judiciary, which must be strong as well as respected. So, the question is that, is the praise of Prime Minister from a member of judiciary a bad idea? Now, Justice Arun Mishra publicly showered praise on Prime Minister Narendra Modi at an international platform during International Judicial Conference of 2020, where the theme of the discussion was Judiciary and the Changing World. Now, such instances where senior most judges of Supreme Court indulges in praise of the highest executive prompts other members from judicial fraternity to follow the same, and this may be done in a hope for a future reward from the executive. And this allows a system of quid pro quo, that is, something for something, to be established between members of judiciary as well as executive. And this correlation or this system of quid pro quo, that is something for something, greatly hampers the concept of judicial independence as envisaged in the Indian Constitution, as it also increases the dependence of various forms between members of judiciary as well as executive, thereby hampering the concept of judicial independence. Now, recently, even the Prime Minister applauded the Supreme Court by referring to some recent critical judgments and also mentioned that 1.3 billion Indians wholeheartedly accepted the judicial verdicts. Now, here it's important to remember about Article 141 as well as 142 of the Indian Constitution. And here it is important to know about Article 141 and Article 142 of the Indian Constitution. Now, Article 141 says that the law declared by Supreme Court shall be binding on all courts within the territory of India. And according to Article 142, in order to do complete justice, the Supreme Court can give any order or any judgment, and such order or judgment shall be enforceable throughout the territory of India. So, it basically means that any judgment of the Supreme Court is not only binding on all the courts of this country, but also enforcement of these orders or decrees or judgment shall be enforceable throughout the territory of India. And according to Article 142, the Supreme Court, in order to do complete justice, can give any judgment, and such judgment shall be enforceable throughout the territory of India. So in this respect, both Article 141 and 142 becomes important from our examination perspective. Also because in 2019 itself, UPSC in the prelims examination asked a question directly mentioning about Article 142 of the Indian Constitution. Let's go through that question first. The question reads, with reference to the Constitution of India, prohibitions or limitations or provisions contained in ordinary laws cannot act as prohibitions or limitations on the constitutional powers under Article 142. It could mean which one of the following? So basically a question on Article 142 was asked in the year 2019 by UPSC. Options were A. The decision taken by Election Commission of India while discharging its duties cannot be challenged in any court of law. No, this was incorrect. B. The Supreme Court of India is not constrained in the exercise of its powers by laws made by the Parliament. Yes, this was the right answer. However, let's go through the other two options as well. C. In the event of grave financial crisis in the country, the President of India can declare financial emergency without the counsel from the cabinet. No. And D. State legislatures cannot make laws on certain matters without the concurrence of union legislature. No. So we see that a direct question on Article 142 with respect to power of the Supreme Court to give judgment in order to do complete justice has been asked by UPSC in the prelims of 2019. So in this regard, we must understand that the judgment given by Supreme Court are to be followed in India according to Article 141 and 142 of the Indian Constitution. And the courts of the country and even the central government cannot refuse to follow the orders of the Supreme Court of India, however critical they may be of the central government. So considering Article 141 and 142 with respect to powers of Supreme Court, let us understand in this context that why an independent judiciary is important for any democratic country, including India. The Supreme Court of India plays a very major and significant role in administration of law and justice, and it is also the final arbiter as well as interpreter of the Constitution of India. Further, judicial review is a basic structure of the Constitution, and this places a special responsibility on the Supreme Court in the area of constitutional interpretation. Further, it is the final court of appeal in public and private law, and the Supreme Court also enjoys advisory, appellate, as well as original jurisdiction. Now, with respect to various landmark judgments in the past, Supreme Court has played a creative and balanced role in keeping the responsible and parliament system of government in proper working order, and also has played a major and critical role to maintain federal balance between center as well as states. Further, the Supreme Court through various important landmark judgments has provided and expanded the contours and jurisdiction of fundamental rights as provided in Part 3 of the Indian Constitution. The Supreme Court through its various and important landmark judgments has endeavored to promote a welfare state in the country as envisaged through Article 38 of the Indian Constitution. And the Supreme Court has also ensured a balance between fundamental rights as well as directive principles of state policy through important landmark judgments. So in this regard, we understand that judicial independence is very much necessary and important so that the Supreme Court, along with its subordinate court, carries out administration of law and justice in India without any fear or favor. So in this regard, we must understand that an independent judiciary is an essential condition for any vibrant democratic system. In other words, we can also say that independent judiciary is sine qua non or an essential condition of any vibrant democratic system, including India, as only an independent judiciary can provide protection for the rights of individuals and also provide justice to all sections of the society without any discrimination as well as without any fear or favor from any particular side. Now, independence of judiciary is also important because the judiciary, or primarily the Supreme Court, is the protector and guarantor of the Constitution of India. And in order to protect the Constitution, at times it may have to strike down any law made by the executive, administrative, or which is made by any legislative acts of central government or of the state government. So, in this regard, judicial independence is necessary so that rule of law can be maintained. Thus, the highest court of the land, that is Supreme Court, must be allowed to function in an atmosphere of independence and must be insulated from all kinds of pressures, including political or otherwise. So in this regard, let us understand some of the important salient features with respect to judicial independence as provided in the Indian Constitution. So in this regard, let us discuss some of the salient features of judicial independence as provided in the Indian Constitution. The first and foremost is with respect to separation of power between legislature, executive as well as judiciary. And here Article 50 specifically mentions about separation of power between the executive as well as the judiciary in public services. Another important aspect to be noted is that separation of power is also one of the basic feature of the Indian Constitution. And this basic feature with respect to separation of power between legislature, executive and judiciary makes judicial independence more important. The next important aspect is with respect to security of tenure of judges, and this has been provided descriptively in Article 124 of the Indian Constitution with respect to appointment of the Supreme Court judges as well as with respect to removal of the judges. Further, the process of removal of judge of a Supreme Court cannot be abused by Parliament because the Constitution provided that a separate law shall be enacted by the Parliament, and accordingly the Parliament has enacted the Judges Inquiry Act of 1968. And last year in 2019, UPSC asked a question elaborately on Judges Inquiry Act 1968 in the prelims examination. So, effectively, the power vested in Parliament with respect to removal of judge of Supreme Court or High Court cannot be abused, as we have a specific and a separate law with respect to removal of judge of Supreme Court or High Court on specific charge of misbehavior or incapacity. Now, the UPSC also asked that whether these two words, that is misbehavior or incapacity, have been defined in the Indian Constitution or not defined in the Indian Constitution. Further, a special majority is required in both houses of Parliament, that is in Lok Sabha as well as Raj Sabha, for removal of Supreme Court judge. So we see an elaborate mechanism with respect to removal of judge of a Supreme Court as well as High Court. And the law has provided enough checks and balances so that this power of Parliament is not abused either by the ruling majority or by the members of opposition. So in this regard, let us go through some of the important aspects of Article 124 of the Indian Constitution. Article 124 says that there shall be a Supreme Court of India consisting of Chief Justice of India, and until Parliament by law prescribes a larger number of not more than 7 judges. Now this number has been changed, and after amendment, as of now, there are 34 Supreme Court judges, including the Chief Justice of India. Article 124(2) says that every judge of the Supreme Court shall be appointed by President by warrant under his hand and seal and on the recommendation of National Judicial Appointment Commission. Now this part of the Constitution as of now is inoperative because a 5-judge Constitution bench has declared National Judicial Appointment Commission as unconstitutional because it violated the concept of separation of power between executive and judiciary. So as of now, the National Judicial Appointment Commission does not function. So, every judge of the Supreme Court is appointed by the President by warrant under his hand and seal through the process of collegium. Now, the Supreme Court declared National Judicial Appointment Commission as unconstitutional because it found executive interference in judicial process. Further, it provides that a judge may be removed from his office in the manner provided in Clause 4, that is, this clause. So clause 4 of Article 124 says that a judge of a Supreme Court shall not be removed from his office except by an order of the President passed after an address by each House of the Parliament has been done. So the proposal to remove a Supreme Court judge has to be passed after an address by each House of Parliament, and this has to be supported by a majority of total membership of that House and by a majority of not less than 2/3 of the members of that House present and voting. And this voting shall be done in the same session, and the grounds of removal shall be proved misbehavior or incapacity. So these are the points provided under Article 124 Clause 4 with respect to removal of judge of a Supreme Court. Further, Article 124 Clause 5 says that Parliament may by law regulate the procedure for the presentation of an address and also for the investigation and proof of misbehavior or incapacity of a judge as provided in clause 4. And accordingly, Parliament enacted the Judges Inquiry Act of 1968, which provides for an elaborate process with respect to removal of a judge of a Supreme Court as well as High Court on proven grounds of misbehavior or incapacity. So, after understanding Article 124 Clause 4 and Article 124 Clause 5, let us go through this particular question asked by UPSC in the prelims of 2019. The question was, consider the following statements. First, the motion to impeach a judge of Supreme Court of India cannot be rejected by the Speaker of the Lok Sabha as per the Judges Inquiry Act of 1968. So, it means that we must know the provisions of Judges Inquiry Act 1968 with respect to removal of judge of a High Court or Supreme Court. Now, in this instance, the first statement is incorrect, as the Speaker of Lok Sabha or even the Chairman of Raj Sabha can reject a motion to impeach a judge of Supreme Court or even that of a High Court. Second statement, it says that the Constitution of India defines and gives details of what constitutes incapacity and proved misbehavior of the judges of the Supreme Court of India. No, the Constitution of India simply provides for these two words, that is proved misbehavior or incapacity, and does not define or either give details with respect to these two specific words. So here again this statement becomes incorrect. Now option number 3. The details of process of impeachment of judges of the Supreme Court of India are given in the Judges Inquiry Act of 1968. Yes, this statement is correct. Fourth, if the motion for the impeachment of a judge is taken up for voting, law requires the motion to be backed up by each house of the parliament and supported by a majority of total membership of that house and by not less than 2/3 of the total members of that house present and voting. Now this exact provision has been provided in Article 124 Clause 4 of the Indian Constitution. It says that a judge of the Supreme Court shall not be removed from his office except by an order of the President passed after an address of each House of Parliament, that is both House of Parliament, supported by a majority of total membership of the House and by a majority of not less than 2/3 of the members of that House present and voting. So the fourth statement also becomes correct. So the question was, which of the statements given above are correct? So here the correct answer was C, that is 3 and 4 only. So we understand that we not only need to know the exact details of constitutional provisions with respect to Supreme Court judge and his removal, but also the detailed process with respect to Judges Inquiry Act of 1968. Now moving to other salient feature, it says that salary of a judge cannot be reduced during his tenure. Now salary of judges is fixed by Parliament, but it cannot be reduced during the tenure of a judge. Parliament may prescribe certain privileges, allowances, leaves and pension of a judge subject to certain safeguards. However, these cannot be varied or reduced during the tenure of judge to his disadvantage. Now this also acts as one of the important features for judicial independence, and this has been provided in detail under Article 125 of the Indian Constitution. Article 125 says that there shall be paid to the judges of the Supreme Court such salaries as may be determined by Parliament by law, and until provision in that behalf is made, such salaries are specified in the second schedule to the Indian Constitution. Next, it highlights that every judge shall be entitled to such privileges and allowances and to such rights in respect of leave of absence and pension as may from time to time be determined by or under law made by Parliament, and until so determined, such privileges. However, these rights with respect to privileges, allowances, or with respect to leave of absence or pension shall not be varied to the disadvantage of the judge after his appointment. So this aspect under Article 125 also act as one of the salient features for judicial independence. Further, the jurisdiction of High Court and Supreme Court cannot be diminished by Parliament. So, Parliament cannot reduce jurisdiction of High Court or Supreme Court with respect to passing any law on appeals or with respect to Supreme Court's various jurisdiction, either original jurisdiction, appellate jurisdiction or advisory jurisdiction. Further, the Constitution insulates judges from criticism in Parliament and state legislature. So, the Constitution has provided that neither the Parliament nor the state legislature can discuss the conduct of judge while discharging his duties either in Parliament or in the state legislature. So, Article 121 and 211 of the Indian Constitution has provided for certain restriction on discussions in Parliament with respect to conduct of judges. So Article 121 says that no discussion shall take place in Parliament with respect to conduct of any judge of the Supreme Court or of a High Court in the discharge of his duties except upon a motion for presenting an address to the President praying for the removal of judge. So unless and until a motion has been moved in the Parliament with respect to removal of a judge of a High Court or Supreme Court, no discussion shall take place in the Parliament with respect to conduct of any of the Supreme Court judge or a High Court judge with respect to discharge of their official duties. And similar provision has been provided in Article 211 regarding restriction on discussion in the state legislative assemblies. And the Supreme Court, while giving its judgment in the Keshav Singh case, highlighted the importance of Article 121 as well as 211 of the Indian Constitution, and said that this provision protects a judge of court from any contempt proceedings which may be taken against him or her in discharge of their duties. So these provisions provides absolute constitutional prohibition against any discussion on the conduct of Supreme Court and High Court judge except when a motion has been proposed for their removal. Now another important aspect is with respect to expense of Supreme Court. Now the Constitution says that expense of Supreme Court shall be charged upon Consolidated Fund of India. Now this provision has been provided under Article 146 Clause 3 of the Indian Constitution. It says that the administrative expenses of the Supreme Court, including all salaries, allowances and pensions payable to or in respect of officers and servants of the court, shall be charged upon the Consolidated Fund of India, and any fees or other monies taken by the court shall also form part of that fund, that is the Consolidated Fund of India. Now this means that salaries, allowances as well as pensions and also any fees or other monies taken by the court shall not be subject to voting in the House of Parliament, and only discussion can take place on such issues. So effectively this provision allows for financial independence of Supreme Court with respect to the amount for their administrative expenses. And accordingly this provision also acts as one of the important features of judicial independence. And another special feature is with respect to collegium system of appointment. See, the Constitution does not provide specifically for this collegium system, but over a period of time and through the development of 3 judges case, the collegium system of appointment for judges of Supreme Court and High Court has evolved. And even in the recent National Judicial Appointment Commission decision, Supreme Court held that the National Judicial Appointment Commission is constitutionally invalid or it is unconstitutional as it found interference by the executive in judicial appointments. So all these collectively can be said to be some of the important salient features of judicial independence as provided in the Indian Constitution. Now question in your mains examination can be asked with respect to salient features of judicial independence as provided in the Indian Constitution. So these are the points which you can highlight while writing your answer for mains examination. Now moving on to the next question, that is there a possibility of erosion of judicial independence despite constitutional guarantees? The simple answer is yes, as there is no constitutional bar on retired judges whether to not join politics or to not join any of the government services. So there is always a lurking danger of judicial independence being eroded by prevailing practices of government re-employing retired Supreme Court or High Court judges at times also as governor of a state and also in other executive capacities. Now even Law Commission reports have highlighted that retired Supreme Court judges should avoid re-employing with the government at any executive post. However, such retired judges can be appointed as chairperson or members of any commission as it requires their expertise in various aspects. So, with respect to re-employment of these retired Supreme Court judges, there is always a chance that the Supreme Court judge, prior to his retirement, might give judgments in favor of the present government or in favor of the then government in power. Further, there is also no constitutional bar with respect to retired judges joining active politics. So, this may also have an impact on various judgments given by such judges. Another important aspect is with respect to the nexus between judiciary, bureaucracy, politics, and business. As it is mostly observed that most of these retired Supreme Court judges act as arbitrators in various cases of arbitration. So, various companies, organizations, or industries are interested in appointing these retired Supreme Court judges as arbitrators. So, it is possible that these judges might give judgments in favor of such business industries or such corporate organizations. So, there is always a lurking danger of this nexus being developed between judiciary and other aspects of society. Now, in one of the cases of Nixon M. Joseph versus Union of India, Justice Narayan Kurup observed that to maintain dignity and independence of judiciary and also to pose public confidence, judges should not allow their judicial position to be compromised at any cost and opposed such practices of re-employment of retired Supreme Court judges with the government or with any political party. However, in this case, no specific judgment was pronounced in order to bar such practices by retired Supreme Court judge. So, with respect to judicial independence, the article has mentioned about standard of conduct and also about implementing the Judicial Ethics Charter, specifically with respect to the restatement of values of judicial life, which was adopted by the Supreme Court in May 1997. So, in this article, the author says that the standard of conduct for a judge should be higher than expected of a layman, and therefore the judge cannot lead a fallen standard of life in the society and should avoid such fallen standards in the society. Further, these judges of higher echelons, basically of Supreme Court and High Court, should not be mere men of clay. That is, they should not have any of the frailties of weakness of character which is found in other people. Rather, these judges should be men of fighting faith with tough fiber and not susceptible to any pressure, either economic, political, or any other kind of pressure. The author further highlights that the behavior of the judge should help people to reap fruits of democracy, liberty, as well as justice. And if there is any frailty in the behavior of judge or with respect to any integrity, then it distorts the entire concept of rule of law in a society. And accordingly, the author in this regard has asked the judges to follow the charter called the Restatement of Values of Judicial Life, which was adopted by Supreme Court in May 1997. And this charter has a total of 16 points to be followed by the judges of Supreme Court. Now, this charter was adopted to serve as a guide and to be observed by the judges of High Court and Supreme Court, which according to the charter was an essential for an independent, strong and respected judiciary, which is indispensable in the impartial administration of justice. Now, this charter, which was adopted in 1997, is a complete code of canons of judicial ethics and thereby becomes important from the perspective of GS paper 4. And this charter categorically declares important values to be adhered as well as cherished by the judges of Supreme Court. Another important point highlighted in this article is that a judge should practice degree of aloofness consistent with the dignity of his office, and every judge must at all times be conscious that he or she is under public gaze and public surveillance, and there should be no act or omission by them which is unbecoming of high office they occupies and the public esteem in which the office is held. So it is important for these judges to follow these canons of judicial ethics in order to maintain judicial independence and in order to avoid interference from the executive or from any of the political parties or business conglomerates. Now, we have provided these 16 points with respect to the Charter of Canons of Judicial Ethics in the PDF, whereby you can go through those exact 16 points. So we understand that this topic of judicial independence becomes a very important topic both from our prelims as well as from our mains perspective, as questions have been asked previously on similar topics with relating to judicial independence in the prelims examination, and questions can be expected in your mains examination on judicial independence either in GS paper 2 or in GS paper 4, specifically with respect to the paper of ethics, integrity and so after our discussion, this forms your practice question for the day. The question is, an independent judiciary is sine qua non of a vibrant democratic system. In light of the statement, discuss the salient features of judicial independence as provided in the Indian Constitution. And this question is of 15 marks and you have to answer this question in 250 words. I hope after our today's discussion, you will be able to answer this particular question if asked in your mains examination. With this elaborate discussion, let's move on to our next topic of discussion. The next news appears on page number 11 in the article section. It says a US strategy only meant to isolate China, and this strategy is with respect to Indo-Pacific strategy. It says that India would be advised to study the Indo-Pacific strategy instead of jumping into it too early or too eagerly. Now this article starts by mentioning about the Indo-Pacific strategy, which is going to promote free, fair and reciprocal trade. However, the article says that these phrases, that is free, fair and reciprocal trade, are not explained in one of the documents of United States. Rather, these reports carries the deeply buried and deeper agenda of United States government, that is to use three large Asian states, namely India, Australia and Japan, to isolate China and also to increase US presence in the area. So, with the center of gravity of geopolitics shifting from the Atlantic Ocean towards the Pacific Ocean in recent times, the United States is desperately looking to increase its military presence in the region, mainly to counter increasing Chinese influence. So, the United States Indo-Pacific strategy has devised towards the objective and involves partnering with three major countries in the region, namely Australia, India, as well as Japan. While there are areas of convergence in the Indo-Pacific construct, these countries have to be wary of the fact that United States' sole objective is to isolate China and to increase its military presence in the Indian Ocean as well as in the Pacific Ocean. So the question is that why United States want to isolate China? Now United States finds China's Belt and Road Initiative objectionable as it has gathered more than 70 countries along with it. And accordingly, China is increasing its sphere of influence. Now China, with the help of Belt and Road Initiative, wants to end its reliance on Western markets. And this is what the United States do not like. Further, China wants to use its surplus in its economy to build infrastructure in key parts of Africa, Asia, as well as Latin America. And in this regard, even one of the key ally of United States, that is Saudi Arab, has made Belt and Road Initiative an important part of Saudi Vision 2030 plans. Further, China has also invested around $68 billion in China-Pakistan Economic Corridor, which starts from Xinjiang in China to Gwadar in Pakistan. And even the Saudi government is spending $10 billion to develop the Gwadar port. Now, as of now, the United States is following the policy of America first and therefore has little or no interest in funneling money in the region which is currently developed under Belt and Road Initiative. So accordingly, the United States wants to increase its military presence in the Pacific and Indian Ocean. So this article says that effectively China seeks to displace United States in the Indo-Pacific region. So in response, the US has developed the Indo-Pacific strategy, which entails US to fight for its dominance in the Pacific Ocean region, Indian Ocean region, as well as along the Asian rim. Another important aspect highlighted in the article is that US cannot economically counter China, so it is trying other ways, that it is going for military deals with other countries to increase its own sphere of influence, especially in the Indo-Pacific region. And as already mentioned, that the United States accordingly wants to use three large Asian countries, namely India, Japan, as well as Australia for this purpose. So in this aspect, this article says that US, in order to downgrade China, is making rhetorical statements in order to counter China. as the United States says that it has more respect for transparency, human rights, and democratic values. However, the author contradicts this claim of the United States and says that hardly their trade deals are transparent. Further, the United States has offered Nepal roughly around $500 million in form of grant, and this is seen as a strategy to gain access to uranium reserves recently discovered in Mustang area near Nepal-China border. So, following this policy, in May 2018, the United States Military Specific Command was renamed as the Indo Pacific Command. And this is seen as a mere symbolic gesture that provides a military aspect to the Indo Pacific strategy. Now, this concept of a military aspect of Indo Pacific strategy is opposite to what India and Japan understand. Whereas in contrast, both India and Japan believes in a free and open Indo-Pacific area and does not believe in any military aspect of the Indo-Pacific region. So in this regard, this article concludes by saying that India should not jump into the policy of United States with respect to military aspect of Indo-Pacific strategy and rather should refrain from becoming a subordinate ally of the United States in reshaping Asia. Now, this particular question was asked in the mains of 2019 in GS paper 2. The question was, what introduces friction into ties between India and the United States is that Washington is still unable to find for India a position in its global strategy which would satisfy India's national self-esteem and ambitions. Explain with suitable examples. And this question was of 15 marks and to be answered in 250 words. So we understand that of late, growing interest of India and United States have prompted UPSC to ask this question in 2019 in GS paper 2. So, as per our today's discussion, you can solve this particular question for your mains examination. The question says, India should pursue a foreign policy which is independent from any international pressure or interest and should help to develop economic and strategic interest of India in the Indo-Pacific region. Comment. So I hope after our discussion you will be able to write this particular question. Now this question is also of 15 marks and has to be written in 250 words. The next news also appears on the article section on page number 11. It says, not fair, just or reasonable. Preventive detention laws practically sacrifice due process interest at the altar of crime control. Now this article effectively highlights about preventive detention laws and its lack of procedural fairness and has also discussed in detail about the process followed in Jammu and Kashmir Public Safety Act of 1978. So effectively this article provides for these four aspects. First, with respect to Jammu and Kashmir Public Safety Act of 1978. Second, need for preventive detention laws in India, both at the center and state level. Third, it describes about lack of procedural fairness and also provides a way forward. Now this topic with respect to Jammu and Kashmir Public Safety Act of 1978 has already been discussed in DNS dated 16th February 2020 and this news was discussed with respect to detention of former bureaucrat Shah Faisal. So in this aspect let us also revise this particular aspect of Jammu and Kashmir Public Safety Act 1978 as details of this also has been provided in this particular article and also other three aspects with respect to this article. Now, Article 22 of the Indian Constitution provides for protection against arrest and detention in certain cases. So, it says that no person who is arrested shall be detained in custody without being informed. So, any person who is arrested by the police should be informed about their grounds of arrest. Further, Article 22 says that such person who is arrested shall not be denied the right to consult and to be defended by a legal practitioner of his or her choice. So it also provides for right to be represented by a lawyer of one's choice. So if a person is arrested by the police, then they have the right to be represented by a lawyer of their own choice. It further highlights that every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest. Thus, this becomes another important requirement that when a person is arrested by the police, they must be produced before the nearest magistrate within the period of 24 hours. And lastly, this article says that no such person shall be detained in custody beyond the said period, that is, beyond the period of 24 hours, without the authority of a magistrate. So, if the police wants custody of any person for more than 24 hours, then they have to get orders from the court or from the magistrate. So, these are the basic criteria for Article 22 with respect to protection against arrest and detention in certain cases. However, there are certain exceptions which has been provided in Article 22 Clause 3. It says that nothing whatever has been provided above shall apply to the following two instances. First, to any person who for the time being is an enemy alien. And second, to any person who is arrested or detained under any law providing for preventive detention. So we understand that all these provisions of Article 22 shall not apply to an enemy alien as well as to any person who has been detained or arrested under any of the preventive detention law in India. So in this regard, let us understand about the Public Safety Act of Jammu and Kashmir, which is a preventive detention law. So under this act, all these provisions of Article 22 shall not apply to any person who is charged under the Public Safety Act of 1978. So we understand that the Jammu and Kashmir Public Safety Act of 1978 is a preventive detention law, and under this law, a person may be detained if the government thinks that such a person hampers the security of the state, or if the government thinks that such a person may disturb the maintenance of public order in that particular area. And accordingly, such orders for preventive detention can be issued by either the divisional commissioners or the district magistrates as per the act, if they are satisfied that a person may hamper obstruction or security of the state, or if they disturb the maintenance of public order, or if the district magistrates or the divisional commissioners think that a person is involved in instances or cases of smuggling timber or liquor, or such person is either helping people in smuggling timber or liquor or harboring people to smuggle timber or liquor. So these are the conditions as per this act under which a person may be detained under the Jammu and Kashmir Public Safety Act of 1978, and such orders may be passed by the divisional commissioners or the district magistrate. So the question is that what happens when a person is charged or arrested under the Public Safety Act? So when a person is arrested, the district magistrate or the divisional commissioner then communicates to the person who is arrested within a period of 5 days or a maximum up to 10 days in writing the reason for their detention. However, the district magistrate or the divisional commissioners have the authority to not disclose all material facts relating to the grounds of arrest if they believe that such facts are against public interest. Now, this communication in writing to the person who is arrested under PSA becomes important on two grounds. First, this becomes the only formal communication by the state authorities to the person concerned who is charged under PSA. And secondly, this formal communication with the person arrested becomes the basis on which they can go for further legal recourse to Supreme Court or High Court. That is, they can further file a writ petition in the High Court with respect to habeas corpus in High Court or Supreme Court with respect to their release. So it is in this instance, this communication done by the district magistrate or divisional commissioners to the person concerned who is charged under PSA becomes very important. However, such district magistrates have the authority or discretion not to disclose all material facts or the grounds for arrest of that person under PSA if such facts are against public interest. Further, the district magistrate shall also provide an opportunity to the person who is arrested or charged under Public Safety Act to make a representation against such order. However, such representation has to be made only by the person himself. Next, the DM shall place the detention order for a person charged under PSA before the advisory board within period of 4 weeks. So, the district magistrate shall place before the advisory board the grounds of arrest of such person under PSA and if any representation was made by that person by himself. The advisory board shall consist of 3 members, of which one should be the chairman. The qualification for the chairman would be who is or has been judge of a high court, and 2 members who are judges of high court, who have been judges of high court, or who are qualified to be appointed as judges of high court. So after this report has been submitted by the district magistrate to the advisory board, the advisory board within 6 weeks from the date of detention of the person charged under PSA shall submit its reports to the government, and its report shall be binding on the government. Now even the advisory board, if it thinks fit, can hear the person who is charged under PSA. However, no legal representation is allowed by the person charged under Public Safety Act, either before the district magistrate or before the advisory board. So within 6 weeks from the date of detention of the person charged under PSA, the advisory board shall submit its report to the government. And the advisory board may either allow for the release of the person concerned or can allow for further detention of the person charged under PSA. And once a person is allowed to be released, then the government shall immediately revoke the detention of the person charged under PSA. However, if the board advises for further detention, then the government can continue the detention of the person charged under PSA. However, such detention cannot exceed the maximum period of 2 years. So these are some of the important aspects as well as procedures for a person who is charged under Public Safety Act. So after understanding the Jammu and Kashmir Public Safety Act, let us understand the need for preventive detention laws as provided in this article. Now this article says that these preventive detention laws exist both at the central level as well as the state level. And primarily, these preventive detention law deals with security of the state as well as with respect to disturbance of public order. And these preventive detention laws are basically used by the state authorities as an effective measure to prevent occurrence of crime in the state. Now mostly under these preventive detention law, either the district magistrate or divisional commissioner or commissioner of police are empowered to pass orders for arrest and detention. And normally, the chances of fair trial is very much minimized under such preventive detention law. Another important aspect to be noted is that the preventive detention orders are based on personal satisfaction of district magistrate or divisional commissioner or commissioners of police. And if these authorities are satisfied that a person's conduct is posing a risk to safety and security of state, or the conduct of a person might hamper public order, then such person can be detained under any of the preventive detention law, either under the central preventive detention law or under any of the state preventive detention law. So with respect to center, the act is National Security Act of 1980, and this act permits arrest and detention of persons when it is in the interest of maintaining public order. So any person can be charged under this preventive detention law if the authorities, that is the district magistrate or commissioners of police, are satisfied that any person poses threat to either security of the state or to public order in the area. Now another important aspect highlighted in this article is with respect to lack of procedural fairness with respect to preventive detention law. It says that such preventive detention laws avoid criminal trials like other regular criminal proceedings, because for criminal proceedings the state authority needs to inform the accused of the grounds of arrest or the grounds on which the person is charged of any crime. However, in preventive detention law, the state authorities need not immediately inform the accused of the grounds of arrest. Another important aspect is that arrested person under any preventive detention law need not be produced before court within 24 hours as is mandated as per Article 22 of the Indian Constitution. Further, the article says that subsequent checks and scrutiny is heavily guarded by state authorities, and this reduces the chances of a fair trial, and it effectively increases unfairness in such proceedings. Further, there is no judicial oversight if detention is sought beyond a period of 3 months. And even in such cases of preventive detention where the case go to the tribunal, which comprises of certain judges, there is no public hearing involved, and also there is no guaranteed oral hearing for the person detained. So all these aspects reduces fairness with respect to procedures under preventive detention law. Further, the orders of the tribunal are not published and hence are not publicly available for any comment. So this brings about more opaqueness with respect to conduct of trial under preventive detention law. Further, even legal assistance is somewhat restrained, and this aspect goes against the very basics of human rights to provide legal assistance to any accused, and it also goes against the provisions of Article 22 of the Indian Constitution. As we have already seen, that legal representation before district magistrate or even advisory board under Jammu and Kashmir Public Safety Act is not allowed. So, all these aspects effectively limit the procedural fairness under preventive detention law for any accused. So, the only opportunity for such accused is to file writ petitions in High Court or Supreme Court for release of the person. But even while filing writ petition in High Court, the case is at times delayed, and this overall vitiates the entire process of procedural fairness. Now, another aspect highlighted in this article is that preventive detention law should be used in exceptional circumstances. However, state has the power to use these preventive detention law even in regular cases. So, more frequent use of these preventive detention laws reduces fairness with respect to trial and various procedures. So, effectively, this article concludes or ends by saying that procedures of preventive detention laws in India practically sacrifice due process interest at the altar of crime control. Now, the whole agenda is to control crime, and in order to control crime, in most of the cases, preventive detention laws are used in exceptional circumstances, and use of preventive detention law in India practically sacrifice due process of law or due process with respect to trial. And because of use of preventive detention law, proper due process of trial does not take place. And the article says that this bargain is ill suited to justice, no matter how grave the risks are. So, in this regard, the government should think towards making certain changes in preventive detention laws in India, both at the center as well as in the state level, and should make it less draconian by providing more human rights for the accused. Now, specifically with respect to Jammu and Kashmir Public Safety Act, it must provide for right of legal representation through a lawyer for detainee's choice before the district magistrate as well as before the advisory board. Now, at times it is also observed that parallel proceedings are initiated against a accused, one under preventive detention law and another under normal laws. So, government must come up with a law which must ensure that if charges are framed either under preventive detention law or in any state preventive detention law, namely Public Safety Act, then regular criminal charges must be either withdrawn or transferred under the preventive detention law or under the Public Safety Act of Jammu and Kashmir. Further, it says that it must be ensured that if writ petition is accepted by High Court or Supreme Court against the detainee, then such petition must be entertained within a period of 15 days and the process should not be delayed further. This will not only help in expediting the legal process but also help in providing bail to the accused who has been detained under any of the preventive detention law. So these are some of the instances of way forward as provided in this article with respect to preventive detention law. Thus, this article primarily becomes important from the perspective of mains examination under GS paper 2 as well as GS paper 3 with respect to internal security and security challenges and their management in border areas. The next news to be discussed also appears on the article section on page number 10. It says issues around data localization. The contentious clauses on local data storage in the revised Personal Data Protection Bill 2019 needs re-examination. Now, this article has mentioned about Personal Data Protection Bill which has been presented in the Parliament in 2020. However, this particular bill has been referred to Joint Parliamentary Committee and as of now, it is in a process to seek public views. Now, this bill wants to give greater control over how personal data is collected, used and stored to normal residents. However, there are still certain flaws as has been highlighted in this article in this Personal Data Protection Bill of 2019. And these flaws are with respect to exceptions created for state for transfer and use of personal data, limited checks on state surveillance with such use of personal data, and deficiencies in the structure and process of data protection authorities. However, apart from these flaws, this article has focused on the issue of data localization in the draft bill of 2019. So in this aspect, first of all, let us understand what does the word data localization means. Now, data localization refers to storing as well as processing of data within borders of a country. Now, it is important to know that as of now, data in India is mostly stored in clouds outside Indian jurisdiction, that is, outside the territorial borders of India, and processed as per needs. Further, with respect to data localization, even RBI has issued a circular which mandates payments related data of citizens to be stored only in India, and these payment related data covers payment services data such as data with respect to Google Pay, Paytm, Visa, Mastercard, etc. So all these digital transactions which we do in India has to be stored locally within the territorial borders, and such details cannot be transferred outside the country. So the question is that why data localization is important for India. It helps to secure data of citizens, data privacy, data sovereignty, and overall helps in securing national security. Further, it helps to stop data mining and commercialization of data by different companies. It further highlights that with cloud computing technology, the data of Indian users are stored outside the country's boundaries, and this may lead to conflict of jurisdiction in case of any legal dispute. Further, if data are stored locally, then law enforcement agencies have easy access to such locally saved data, and it also helps to prevent foreign surveillance over local data or over national data. And data localization will overall benefit the growth of local data ecosystem in the country. So these are primarily the reasons why we need data localization laws in India. Now this article has highlighted issues with respect to transfer of data outside India. So in this aspect, the real issue is the need to physically locate data stored within India. And for this aspect, the Personal Data Protection Bill of 2019 has enabled the transfer of data and categorized data into three layers. The first layer is personal data. So transfer of personal data outside India is allowed. However, there are certain restrictions with respect to transfer of data of sensitive personal data and critical personal data. So with respect to sensitive personal data, if they have to be transferred outside India, then a copy of that has to be made and stored in India before transferring such sensitive personal data outside India. Whereas critical personal data has been barred from transferring outside India. So the Personal Data Protection Bill of 2019 has created these three layers, namely number 1 personal data, number 2 sensitive personal data, and number 3 critical personal data, whereby critical personal data is barred from being transferred outside India. Now this article says that the earlier bill of 2018 had more stringent provisions with respect to data transfer outside India, and this provision with respect to data transfer outside India has been in some way liberalized in the present bill of 2019. So effectively the 2019 data protection law provides for a relaxed data localization laws, as it provides for certain liberalized norms for data transference outside India. So the article mentions certain benefits with respect to such liberalized norms of data localization. It says that it is good for business and users, it will reduce business costs, it will create greater flexibility in choosing where to store data, and it is a more proportionate approach with respect to data localization. Now apart from these benefits, the article says that there are certain arguments for stringent data localization laws. These arguments can be categorized into three aspects. First is with respect to the aspect of sovereignty and government functions of such data. Second is with respect to economic benefits which will accrue to local industries, namely creating local infrastructure, providing employment, and also development of artificial intelligence ecosystem. And thirdly, such stringent data localization laws will enhance data privacy and security in India. Further, with respect to security of data, this article says that security of a data does not depend only on location, but rather depends more on other technical expertise such as technical measures taken, skills, cyber security, protocols, data protection laws, etc. And in this regard, whereas data localization makes it easier for data surveillance and also for domestic surveillance over its citizens by the state authorities. So in this aspect, the article has says that data privacy can be ensured through other ways as well apart from data localization, such as by maintaining a contractual obligation or through secondary conditions. And this secondary conditions has been provided in the Personal Data Protection Bill of 2019 by providing a layered data, as we have already seen with respect to personal data, sensitive personal data, and critical personal data. So, in this regard, this article further says that if data privacy is the only problem, then citizens must have the right to choose a location which provides for maximum data security or which provides for maximum data storage. And in such case, California and European Union are the best places to secure data as they have strongest data privacy laws. So in this aspect, this article concludes by saying that the Joint Parliamentary Committee, which is currently examining the Personal Data Protection Bill of 2019, should conduct a more in-depth evaluation of localization provisions in the Data Protection Bill. Now, after our discussion, these forms your practice question for the day, and these questions have been taken from news appearing on page number 8. So, question number 1, it says, consider the following statements. State of Goa and Karnataka are embroiled in a dispute on sharing water of Mahadayi River. Yes, this statement is correct. Second, Mahadayi River originates from Western Ghats and flows through the state of Goa. Yes, this is also correct. Third, Mahadayi River flows into Arabian Sea after crossing the city of Panji. This is also correct. So the question is, which of the statements given above is are correct? So here the correct answer is C, that is 1, 2 and 3. Question number 2. It says, consider the following statements about Hampi. First, Alexander Greenlaw has taken the first detailed photographs of archaeological remains at Hampi. This statement is correct. Second, Hampi has been declared as a World Heritage Site by UNESCO. This is also correct. And third, Hampi is situated in the Krishna Tungbhadra Doab. Yes, this statement is also correct. So the question is, which of the statements given above is are correct? So here D is the correct answer, as options are 1, 2 and 3 only. With this, we come to an end to discussion of today's newspaper. Let's move on to the question for the day.